In this installment, Jack Saraiva is being interviewed by Candice Cooper on the topic of overholding.
Jack, what if a tenant's lease expires and they don't leave the premises as required under the lease?
When a tenant remains in the premises after the expiry of their lease without coming to terms on a new agreement, this is a concept called overholding. Under the common law, the provisions of the expired lease continue to operate, other than the term of the lease, of course. Because of this, landlords will often include provisions in their leases setting the ground rules for what happens if a tenant overholds. They also try to guard against overholding by including provisions discouraging tenants from doing so. The most common term states that if the tenant remains in possession past the expiry of the lease, the tenancy will be converted to month at an increased rent, sometimes double.
Do tenants have a right to overhold? What if the landlord doesn't want them to stay?
There is no right to overhold. Overholding is just the name of the concept when a tenant is permitted to stay in the premises after its term is expired. Under the common law, there is no right to remain in possession past the expiry of the lease term. However, tenants do stay on, which is why the concept of overholding arose, and why there are lease clauses setting the rules for when it happens. In other words, a tenant can only overhold if the landlord consents. If the landlord wants the tenant to vacate, but the tenant refuses, the tenant could be considered trespassing. However, if the landlord accepts rent from the tenant after the expiry of the term, they may be deemed to have accepted the tenant as overholding. So, landlords should not accept rent after the expiry of the lease's term if they want the tenant to vacate.
If the landlord consents to the tenant's overholding, is there a specific amount of time they can overhold for?
It depends. There is no set length of an overhold term. If the tenant's lease has an overhold clause, then the tenant's overhold term will be for the amount of time set out in the clause. For example, it might say the term is month to month or year to year. These shorter, recurring terms are called periodic tenancies. Without an overholding clause, the common law provides that if the lease was for a term less than a year, a month-to-month tenancy will be deemed to have been created. Or if the term was for a term greater than a year-to-year tenancy will be deemed to have been created.
How can a landlord then end the tenant's overholding and get its space back?
Overholding terms, or periodic tenancies, can be terminated by either party, not just the landlord, by giving the correct amount of prior notice. For an overholding yearly tenancy, notice must be provided at least 6 months prior to the end of the overholding lease year. For an overholding monthly tenancy, notice must be provided at least 1 month prior to the end of the monthly term. So, the parties can get out of an overholding term. It's just going to depend on the term of their periodic tenancy and how much notice is required.
So that's why you mentioned earlier that landlords will try to guard against overholding by charging the tenant increased rent if they overhold.
Exactly. Landlords usually don't want their tenants on monthly or yearly tenancies that either party can terminate. They want long-term commitments. That said, if the landlord is okay with the tenant overholding and wants to collect the increased rent during the overhold term, it should do so right away. In a recent decision, the landlord didn't collect the increased rent right away and instead collected the normal rent required under the lease. But after a while, it sought to collect the increased rent. The court said that the landlord had waived its right to the increased rent and so was no longer entitled to it.
Thanks, Jack. That was helpful.
That was Jack Saraiva in conversation with Candice Cooper on the topic of overholding. If you would like to learn more, contact Jack on our website, dv-law.com.
This audio recording was a general discussion and should not be relied upon as legal advice.